Good evening, ladies and gentlemen. It is my pleasure to welcome all of you this evening. My name is Xi'En. I'm a Deputy Counsel at SIAC. This evening, on behalf of SIAC, I have the privilege of introducing our distinguished panelist, who will discuss ICCA's report, Does a Right to a Physical Hearing Exist in International Arbitration? Joining us this evening, Professor Giacomo Rojas Elgueta, Ms. Rachel Tan Xi'En, and Professor Lucy Reed. Professor Giacomo is one of 3 co-editors of the ICCA project, Does a Right to a Physical Hearing Exist in International Arbitration? He's of counsel and head of international arbitration at the Italian firm Xi'En. He's an associate professor of private law at Roma Tre University and a visiting associate professor at NUS. Professor Rojas serves as counsel, expert witness, and arbitrator in both commercial and investment arbitrations. He was recently appointed by Italy to the ICCA panel of conciliators. Thank you, Professor Rojas, for joining us this evening. Rachel Tan, Ms. Rachel Tan, served as the Rapporteur on Singapore for the ICCA Right to a Physical Hearing project. She is the Research and Development Lead at the Singapore International Dispute Resolution Academy, SIDRA, and Associate Counsel at RevLaw LLC, working on a range of commercial and criminal matters. Before SIDRA, Ms. Tan spent 3 years in the Ministry of Foreign Affairs, clerked for an international arbitrator, and practiced in Big Four Singapore law firms. She maintains an active research agenda on international dispute resolution of all types. Thank you, Ms. Tan, for taking your time and joining us this evening. Professor Lucy Reed was involved in the early days of the Right to a Physical Hearing project as president of ICCA. She will serve today as moderator of the panel as the president of SIAC. Lucy was head of international arbitration practice with Freshfields, and from 2016 to 2019, the director of Center for International Law and professor at the Law Faculty of NUS. She now is an independent arbitrator with arbitration chambers in New York. Thank you, Professor, for joining us today. We look forward to a very engaging and enlightening discussion on an interesting theme, and to continuing the discussion over a glass of wine or a cup of coffee afterwards. Thank you.
Thank you, Nasri. Welcome to everyone, and I should add how pleased I am that we can all be here today to have this program. Giacomo is teaching an intensive course with me at NUS these 3 weeks, and Rachel was my teaching assistant before at NUS, so I'm happy to have them all involved. Fortunately, I would say it is increasingly difficult for us to remember the early days of international arbitration during the COVID-19 lockdown. Back in 2020, when physical in-person hearings became impossible in international arbitration, there was much confusion and many questions were raised, particularly not only about how to run a remote hearing, but whether remote hearings would be fair and would lead to enforceable awards in all jurisdictions. There were a lot of delays, and particularly respondents were often in a position of asking for postponements until after the pandemic, but of course no one knew when it would end. To the rescue, I would say, came Giacomo and his colleagues, James Hosking and Yasmin Lalou of the Chaffetz Lindsay firm in New York, who approached us at ICCA and said, we would like to do a multi-jurisdictional survey about the right to a physical in-person hearing versus, by the way, a virtual in-person hearing in various jurisdictions. And it's important to remember this terminology that remote virtual hearings are in-person and live. They're not paper hearings, but we're talking about a physical hearing where human beings are in the room. Our response was, yes, please, do it yesterday. And they launched the project in collaboration with ICCA. I think it was September of 2020. The editors and their national jurisdiction rapporteurs really do deserve all the credit. We agreed early on that the core principles of the project would be focus, comprehensiveness, diversity, relevance, and consistency. And with no humbleness at all, I can say all I did in relation to the project was urge the editors to develop a standard template so that every national jurisdiction report would answer the same questions or address the same questions, and prepare one or two models of filled-in templates so we had a standard of quality and consistency. So fast forward. There are now 78 reports from New York Convention countries available on the ICCA website for downloading for free, available to all. And the reports address questions such as, is the right to a physical hearing expressly provided by, or can it be inferred from the relevant arbitration law? What is the impact of the parties' agreement on the arbitrator's procedural direction to order a remote hearing? And can remote hearings affect the validity or enforceability of an award? These reports have provided hugely important information in the still changing environment of hearings in international arbitration, but for counsel, for arbitrators, for the judiciary, and academics and institutions. And our own Kevin Nash, SIAC registrar, claims to be the #1 user on our ICCA website. We'll have to test that statistically. In September of 2022, at the ICCA Congress in Edinburgh, we launched the Companion General Report as part of the formal ICCA Report series. And in reference to the Edinburgh Castle, I call this the crown jewel of the project. You'll see one shortly. The General Report describes the background and the methodology of the survey, offers high-level conclusions drawn from the answers provided in the national reports, and highlights what the editors found to be converging approaches among the 78 jurisdictions on the survey's key issues, but I'll leave those details to Giacomo. Now, the General Report also contains a series of essays, I think 14, by eminent practitioners and academics positioning the question of a right to a physical hearing in the broader context of public and private international law, considering, for example, the basic requirements of due process, the risks of the online environment in terms of cyber security, the quality of decision-making when hearings are remote, and the observed and potential impact of online hearings on the diversity and inclusiveness of participants in international arbitration, not to mention the environmental benefits of more remote hearings. And I'll quote myself on what I said on the launch of the General Report, and I quote, "I congratulate the co-editors on this comprehensive and easy-to-navigate General Report. It will be valuable to arbitrators, counsel, academics, and the judiciary far beyond the COVID-19 pandemic conditions that inspired the right to a physical hearing project in the first place." Again, thank you for coming today. SIAC plans to post the video of this small conference on our website for wider educational purposes. So now I welcome Giacomo to speak on the project in general, and Rachel to talk about the Singapore findings and recent developments, and we'll have Q&A at the end. Thank you.
Thank you very much, Lucy. Thank you, SIAC, for organizing this event. It is a great pleasure and honor for me to present to you the results of this project. Next slide, please. So as anticipated by Lucy, in early 2020, the arbitration community was facing new legal questions, and in particular, there was one that certainly was the most pressing, whether an arbitrator can order a remote hearing over the objection of one of the parties. Translated into the title of the project, does a right to a physical hearing exist or not in international arbitration? So the idea of the project was to try to address these new legal questions that were arising during the first months of the pandemic. Next slide. So the underlying assumption of our project was that there is no transnational answer to this question, so that was not possible to find an across-the-board answer valid for arbitration proceedings seated in different jurisdictions. So our first approach was that we had to look at both the law applicable at the seat of the arbitration proceedings and also the law at the place where the award would eventually be enforced. So this, of course, called for a comparative law project, and this is when we decided to address ICCA to also have the global reach, exposure, and gravitas that only ICCA could have provided to us. And of course, this is another opportunity to thank Lucy Reed, but also Liz Bosman, Lisa Bingham, and all the ICCA team that provided us an enormous support. Next slide. So as to the methodology of our project, we draw from what I would say the classic toolbox of comparative law, and in particular I'm referring in this slide to the Cornell project that was launched in the 60s by Professor Rudolf Schlesinger at Cornell University, where for the first time a survey was used to collecting comparable answers from experts coming from different jurisdictions. In that case, the project was on formation of contract and looking whether there are core principles in the civil law and common law tradition on formation of contract. But the importance of this Cornell project was that it was an opportunity to understand also how to draft a survey. So how to purge a survey from all the technicalities that belong to a specific legal jurisdiction. So the effort for us was to draft questions that were comparable across different jurisdictions and that were so able to collect comparable answers from our national reporters. And here came the very relevant suggestion from Lucy that in order to increase uniformity, consistency, and quality in our national reports, we had to first draft two templates. So we drafted the Italian and US template. So next slide. And I would skip maybe this one on the founding principles because Lucy already mentioned them, and I would jump to next slide to the timeline of the project. So after having drafted the two templates, we published a call for expression of interest in September 2020, and we were, let's say, overwhelmed by the answer received by the arbitration community. We were expecting to cover around 15 jurisdictions maximum. We received 150 applications, more or less, and eventually we covered 78 New York Convention states. So we sent the questionnaire to the national reporters together with the templates between October and November 2020. In December, we published the first 4 national reports. We called it a teaser to attract attention from the arbitration community. And then eventually we published the 78 reports in 3 batches. So from September to May, this was the core of the work of, let's say, the first half of the project, the one related to the national reports. So then we had to draft a general report trying to summarizing all the 78 national reports, which are all available on a dedicated ICCA webpage. And this is the general report that is in the ICCA number 10 ICCA report that was presented in Edinburgh in September, which includes the general report plus a series of essays, as Lucy mentioned before. So you do not find in this book the 78 general reports. These are thousands of pages. It wouldn't be possible to have them in a book, in a volume. So this was the second half of our project that was concluded and presented in September 2022. So overall, the project was a 2-year project, but I would like to stress that it's an ongoing project. So now we are in the process of updating twice a year the national reports. So what we are doing is sending out an email every 6 months to all the national reporters, telling them that if there is a significant development in their jurisdiction, please update the report. And so you find on the ICCA webpage some reports that are flagged as updated. So most recently, we published the new Sweden and Australian report in the ICCA webpage. Next slide. Very quickly, just to show you the number of national reporters that participated, because all the credits, of course, go to them. Next slides, and we can move on. So in terms of diversity, we have 43% reporters that are women, 50% reporters that holds an academic appointment or position, so we wanted both to involve academia and practitioner in our project. You see a big, significant geographic diversity as well, and 72% of the jurisdictions covered are model law jurisdictions. Next slide. The questionnaire. So the questionnaire is composed of 11 questions, but I would say they cover 6 different main topics that you can read in this slide. But I would now move to try to present to you in a very high-level way the key conclusions from our survey. So next slide. So the first important conclusion is that in no jurisdiction there is an express right to a physical hearing. So no single reporter replied that in the lex arbitri, meaning of course the law that applies to arbitration proceedings in that jurisdiction, is there is an express right to a physical hearing. So the next question, question number 2 of our project, was whether a right to a physical hearing could have been either excluded or inferred by way of interpretation of the lex arbitri. Next slide. And most jurisdictions answer that a right to a physical hearing can be excluded by way of interpretation of the lex arbitri, and here there is a high degree of consistency, because most reporters were stressing the same indicia or the same elements for reaching this conclusion, the most relevant one being the broad procedural discretion provided by the applicable law to arbitration proceedings in that jurisdiction, but that was not the only element highlighted by the reporters, as you can see in the slide. I would like to draw your attention to the third bullet point. For example, many reporters said that the fact that an arbitral tribunal has the power to determine the place, the venue, or the location of the hearing translates into the possibility of determining as a location a remote one. This is interesting because, as we will see in a moment, other reporters, because of the very same wording, reached the opposite conclusion in their jurisdiction. So next slides, we also had a surprising outcome that it was not expected, not covered by our questions. We found 2 jurisdictions where actually a right to a physical hearing is expressly excluded by the lex arbitri, meaning that there is express power for arbitrators to order a remote hearing. This is in the Netherlands and the United Arab Emirates. Of course, this procedural discretion of the arbitral tribunal in all jurisdiction is under the within the limit of the due process principles, and I will get there in a moment. Next slide. Few jurisdictions, on the opposite, answer that actually a right to a physical hearing can be inferred by way of interpretation of the lex arbitri. This is true for Ecuador, Tunisia, Venezuela, Vietnam, and Zimbabwe for, let's say, 3 different reasons. In Ecuador and Tunisia, because the rules of civil procedure serve a gap-filling role to the lex arbitri, and in the rule of civil procedure, there is a right to a physical hearing, and being the lex arbitri silent on that specific point, then the gap must be filled through the application of the rules of civil procedure, which provide for a right to a physical hearing. In Venezuela and Vietnam is where the reporter interpreted the duty of the arbitral tribunal to set the venue or the place of the hearing as meaning a physical one, opposite to what we have seen before. And another argument from the Vietnamese reporter was that in the arbitration rules of the Vietnam International Arbitration Centers provide that a remote hearing can be ordered by the tribunal only upon an express agreement of the parties, and this would be a further element to kind of interpret the lex arbiter. Of course, the arbitration rules are not a law, but this was used as a way to interpret the lex arbitri. In Zimbabwe, on a different note, the reason why the national reporter concluded that a right to a physical hearing exists depends on an infrastructural problem. So the reporter said, of course, a hearing in this country means physical because there is no infrastructure. There are continuous problem in the internet connection, in the power system that will not allow to hold a hearing. So given the circumstances that are obviously more factual than legal, a hearing or an oral hearing must be intended necessarily as a physical one. Next slide. Another group of jurisdiction answered that the issue remained unsettled. So these two groups of countries, in my opinion, prove that our preliminary assumption that there is not a transnational answer to the question proved to be correct, because as you can see, we have countries where right to a physical hearing can be inferred, or countries where the reporter said, well, it is an unsettled matter. What is interesting in this group of countries is that beside China, all of them are model law jurisdiction, and the main problem here is the interpretation of Article 24.1 of the model law, where, as you all know, provides that a party can request the arbitral tribunals to hold an oral hearing, and the arbitral tribunal shall hold a hearing at that point. So the next question is what oral means. While in most jurisdictions the answer is that oral is compatible with remote, in this group of countries, Bahrain, Denmark, Germany, and Norway, for various reasons, I of course don't have the time to go through the various reasons for each country, the reporter said that there are at least minority views or good enough arguments to say that the matter remains at the moment unsettled, and so arbitrator must be very careful to order a remote hearing over the objection of one of the parties. A very special, next slide please, jurisdiction was Sweden, because the reporters from Sweden took the position that in Sweden there is a right to a physical hearing. This created a controversy in the Sweden arbitration community, which convinced us to add an addendum to the national report in order to have both views represented, and the matter was somehow settled in June 2022 with the decision of the Svea Court of Appeal, which said that oral in the Sweden Arbitration Act is the word oral is technological neutral, and therefore is compatible with the remote. Next next slide. So then we had two further questions on litigation, on civil procedure. These questions were intended only in the case the reporter were not able to reach a conclusion from the lex arbitri, and so whether the rules of civil procedure were a resource to find the answer. But in any case, all the reporters answered also to these two questions, and in my opinion, they are very interesting because they help understanding that even in those jurisdictions where the rules of civil procedure provide for a physical hearing, in the majority of them, physicality is not a requirement to meet a certain threshold for calling something a hearing. So while orality, immediacy, sometimes publicity are elements that are necessary to meet a certain threshold, this does not apply to physicality. So I think that also these answers are very interesting. But as we have seen in a minority of jurisdictions, the fact that in the rules of civil procedure there is a right to a physical hearing helped interpreting the lex arbitri. This I said this before. Next slides. As to the setting aside issue, of course, this is relevant also in those jurisdictions that excluded the right to a physical hearing. Does it mean that an arbitral tribunal can always order a remote hearing because there is no such a right? Of course, no. And all the reporters agree that the broad procedural discretion of the arbitral tribunal is limited to due process concerned. So in the next slide, we can see that this is when the arbitrators shall discharge a case-by-case or fact-specific evaluation to understand whether in those circumstances a remote hearing is compatible or not with due process principle, with the right for a party to fully, the opportunity to fully present its case. And in July 2020, there was an important decision by the Austrian Supreme Court exactly on this point, and later another decision in Australia that is refers to domestic arbitration, but is still relevant in clarifying that remote hearings are normally compatible with due process principle, but it is necessary to do a fact-specific evaluation. Now, this evaluation, next slide, and I am approaching the end of my presentation, requires a balancing of interests. So on the one hand, of course, arbitrator must take into account due process and the right of a party to present its case, but as we all know, during the pandemic, there was also a strong argument in favor of remote hearings because the alternative, as Lucy stressed before, was indefinitely postponing a hearing. So the balancing activity was between due process on the one hand and the duty of an arbitrator to render an award within the fixed time limit, or the duty to conduct the arbitration proceedings without undue delay. Now, the interesting question, in my opinion, the one we are facing in more ordinary times, is whether how this balancing activities is changing or has already changed. And here, in the update of the Australian report, there are interesting recent decisions where Australian judges, with regard to court proceedings, are stressing the fact that now that we are back in more normal times, they don't find enough reasons to justify remote hearings. This shows how now due process concerns are becoming again more relevant than the duty to conduct the arbitration proceedings in an expeditious and efficient way. So it is interesting to continue following the developments in different jurisdictions, because also the how due process is applied and interpreted in different countries is, again, a jurisdiction-specific matter, as I think was the result of a volume edited by Professor Franco Ferrari together with Friedrich Rosenfeld, who is with us today. So I think there is a consistency between the two works. So then the second part of the project was the general report and collecting the essays, but we do not have the time to go through them. But again, you can download for free the entire volume on the ICCA website. So thank you very much for your attention.
Thank you, Giacomo. I wanted to stress, I think I forgot to say, that this is downloadable. All the content for free from ICCA. For environmental reasons, actually, we've printed very limited hard copies. We distributed them in Edinburgh, but do not plan to have many hard copies. The essays are pretty good. They don't put you to sleep, that's for sure. So, Rachel, what did you find on Singapore and what's happened since the survey results went in?
So before I answer that question, I must preface my presentation thanking SIAC and ICCA for the invitation. I must say that when I submitted my report, the ICCA committee, Giacomo, James, and Yasmin, looked at the Singaporean cases and asked me for clarifications on Singaporean law. So that was, I would say, as rigorous as any peer review process that I have ever undergone. So I would say that the essays are worth reading. All right to a physical hearing in Singapore. I will not be able to talk about the 12 pages in 15 minutes, but I will offer you 3 things today. First, I will take you through the position in 2021. Then I will give an update on the 2022 cases, because we have had 3 cases from the Singapore Court of Appeal and SICC that have clarified on the scope of physical hearings and the fair hearing rule. So while they do not directly impact on the question of whether a right to a physical hearing is a right in international arbitration, they provide some scope, some guidance as to the scope of how a particular rule could be interpreted. And lastly, I will leave you with 3 questions to consider before I end my presentation. Starting with the 2021 report, in Singapore, the Civil Procedure Rules and the International Arbitration Act are distinct. So they are distinct regimes, they do not cross each other. That is a matter of tried law. Under the International Arbitration Act, no specific arbitral procedure is specified, but the court, this is the Singapore Court of Appeal, has stated in a 2020 decision in China Machine Corps that a tribunal has substantive deference in determining arbitral procedure. So this is the general rule. More detailed rules, such as if you want to challenge an award and raise a procedural ground, first the objection must be raised during the proceeding and not after. Second, the tribunal cannot make an irrational or capricious decision. And third, there must be an element of real prejudice. Only then is the procedural ground made out. In litigation, court litigation, there is a general right to a physical hearing. And as I have listened to Giacomo's presentation, in some jurisdictions, civil procedure acts as a gap filler, right? But in Singapore, the 2 regimes are distinct. However, there is a question: how far will a Singapore court, in exercising its curial discretion, look behind the principles of civil procedure and interpret the rule as to what might constitute a breach of a fair hearing? I will deal with that later. We have one case, 2022 case, Singapore High Court case, which I thought might be interesting to all of you. In this case, a plaintiff brought an application over a dispute, but made an application to testify via video link from China. And this was brought on 2 grounds. First, it was because flight prices were onerous. And it is true, because the last time I checked, a flight from Beijing to Singapore was $8,000. Second, the second ground was that there was a possibility of her catching COVID in Singapore. So what did the judge say to that? The judge said, no, the plaintiff had to come to Singapore physically to testify and be cross-examined by the defendants. And why? Let me read from the extract. This judge said, it is not only important that justice be done, but that litigants themselves see that justice has indeed been done. Often, the vindication litigants receive may not necessarily come from a favorable outcome, but rather from having the opportunity of confronting the opposing party physically in court. In that sense, the perception of litigants as to how the trial is conducted is also a consideration that can and should, in my view, be taken into account in deciding whether leave should be granted. This is leave to testify via video link. In the second part of the judgment, it says, it is to my mind more important that the defendants be allowed to confront the plaintiff in person and be allowed to put questions to her physically in cross-examination. Depriving them of this opportunity could leave them with the impression that they were not fairly treated. So this is a case that was in the Singapore courts under Singapore rules of court and Singapore High Court case. This is what the court said. If I could go back to the first slide, thank you very much. The question is this. If the civil procedure rules and IAA regimes are different, why do such decisions matter? As I've said earlier, and I reiterate this all the time, is because supervisory courts have discretion to interpret and scope rules. And here I would turn to the two 2022 Singapore cases on how the Singapore courts have scoped the fair hearing rule. The first decision was issued in January 2022, and the second decision was issued later in the year in 2022, both Court of Appeal decisions. In the first case, the bench, made up of Chief Justice Sundaresh Menon, Justice Judy Prakash and Justice Stephen Chong, held that the fair hearing rule was breached and set aside the award in its entirety. This dispute was a shipbuilding dispute administered under the auspices of the SIAC with a Singapore seat. There was a delay in the construction of the vessel and a claim and a counterclaim. So the losing party applied to the Singapore courts to set aside the award based on Article 24B of the International Arbitration Act and Article 34(2)(a)(3) of the model law. The High Court, in the first instance, set aside the award in its entirety, and the Singapore Court of Appeal agreed unequivocally. So it did not overturn any of the findings of the Singapore High Court. What are the relevant points from Singapore Court of Appeal's decision? Right? At paragraph 55, it says that the fair hearing rule stipulates that if a tribunal decides an issue on the basis of reasoning which is unfair for the tribunal to adopt because the parties had no reasonable opportunity to address it, there is a breach. And the fair hearing principle requires that the tribunal pay attention to what is put before it and gives a reasoned decision on arguments and evidence presented. So of course, this is a matter of touching into the substance, not so much on the mode of hearing, right? But further on, it went on to say that if the tribunal were to set aside a award on the basis of a defect in the chain of reasoning, a party must establish that the tribunal conducted itself irrationally or capriciously, and the breach must prejudice the respondent's rights. A breach of natural justice will cause prejudice if complying with the rules of natural justice could reasonably have made a difference to the outcome of the arbitration. So all still general rules, but a little bit of flavor as to what constitutes fair hearing. This case was then cited in the second case, CEF and CEG and CEH. There the Court of Appeal disagreed with the Singapore High Court. So the Singapore High Court declined to set aside the arbitral award, upheld the award. But the Court of Appeal, made up of the same bench, said, I will partially allow the setting aside application. So partially set aside. And why? Because the fair hearing rule was breached. Why? Because the chain of reasoning did not have any nexus to the case. And what did the court say? The Singapore Court of Appeal made two interesting observations. First, an argument on the no evidence rule was presented, but the Court of Appeal said this rule has been accepted in Australia and New Zealand, but it's not part of Singapore law. So that's not the reason as to why we allowed the claim to succeed partially. The Singapore Court of Appeal accepted, though, that the breach of natural justice or the inability to present a case with reference to the chain of reasoning rule, such that deficient evidence in support of some things, right, would mean that there was a breach of the fair hearing rule. And there the damages order of 54 million was set aside. You have heard the two cases, and a lot of it seems to be veering into substance, right? And or more going into what the Court of Appeal determined on the basis of evidence presented. So why is it relevant to whether something is physical or remote? Why is it relevant? And my answer is this. The Singapore courts have not shied away from developing curial law to determine the scope of a rule in setting aside an award. So this specific aspect of the fair hearing rule has to do with the chain of reasoning analysis, which has not really been touched on in Singapore jurisprudence before. If you look at the parties' pleadings, the parties pleaded breach of a fair hearing rule or breach of natural justice. It is a court of appeal that said that the chain of reasoning has led to no nexus and therefore is set aside. So the court of appeal does not shy away from developing jurisprudence. So of course, in Singapore, as with the global jurisprudence, there has been no setting aside application made on grounds of deviation of procedure relating to a physical or a remote hearing. But the questions to consider are these, 3 questions. The first question, will the court also consider the principles set out in civil procedure jurisprudence on allowing parties a chance to see that justice is done? It cannot adopt the civil procedure rules, but could it extract the principles to say, we would like to have parties appear physically? It remains an open question. Second, the SICC is now a supervisory court if a particular model clause is accepted. So to what extent will the SICC consider foreign jurisprudence in determining the scope of a rule? Right. In the Singapore Court of Appeal, they did not accept that the Australian and New Zealand positions on the no evidence rule were part of Singapore law, but would the consideration of foreign jurisprudence be a relevant factor in the SICC? My preliminary comment and answer to this in a 24 November 2022 decision issued by the SICC just a few months ago on the setting aside of an award, the SICC was very consistent with Singapore Court of Appeal jurisprudence, cited from the 2 cases just now. But the SICC was also open to considering decisions from Australia, and in fact adopted a position from Australia that parties had not pleaded. In fact, the SICC said, this is a decision that is not referred to by both parties, but it has some resonance with this appeal. So the approach of the Singaporean courts, very robust, I would say, able to develop curial jurisprudence, and will give me a lot more work because it is now time for me to update the 2022 report, which I have not done, and Giacomo has kindly asked me to do. Thank you very much.
I will take my prerogative as moderator to ask Giacomo, in the updates that you're getting from the rapporteurs, have there been national court decisions on arbitration awards focused on remote hearings or physical hearings?
Yes, so we have the update on Sweden, and I showed you before in the slide the this important court opinion of the SIAC Court of Appeal, clarifying that oral is technological neutral. We have the Australian decision on a domestic arbitration, again clarifying that the remote hearing was fair and per se is not a violation of the due process principle, and so it is a fact-specific analysis, the one that must be discharged, but per se a remote hearing is not a violation of the due process. Then we also have an update from South Korea, which was not related to remote hearings applied to arbitration, but to court litigation. So far, we are not aware of any court opinion that vacated or set aside an award because of a remote hearing. So all the few opinions that we collected so far are all in line with the majority of the reports that remote hearings are per se perfectly consistent with the due process principles. I think there is also, but I'm not sure whether it was already included in the original report or it is in our first update, an opinion in Qatar, a court opinion in Qatar. Again, it was a case where the losing party tried to set aside the award because a remote hearing was held, and the agreement provided that the seat was in Qatar, but somehow that the procedure should have been held in Qatar, and the court again dismissed the set aside attempt by the losing party and found that the award was valid. So these are, Lucy, the cases that I have in mind. I don't think that, well, the Austrian cases was early in 2020, so it's not part of our update. I think this is the ones we have collected so far. I just would like to mention that UNCITRAL approached us because at some point when they were reading that most of the discussion was around the word oral in Article 24.1 of the UNCITRAL model law, they wanted to have a virtual meeting with us, and they were even wondering whether it was time for a change in Article 24, and of course James, Yasmin, and me were not. It was actually not our intention at all to put the model law under the spotlight, so please, no. But I think that it was one of the interesting point is the way courts will interpret the expression oral.
A couple of the things that I'm watching in this area. First is what we heard a lot in 2020 and 21 when one of the parties did not want to have a remote hearing for whatever reason and complained about it. The arbitrators and the institutions would say, well, if the courts in your jurisdiction are having virtual hearings, then it must be okay for arbitral tribunals seated in those jurisdictions to have remote hearings. That makes sense to me if there isn't a contrary law. But now that the courts are back in public session and parties and witnesses and counsel are all not only invited but expected to be physically in court, whether that will see something changing in the way arbitrators and institutions rule on whether there should be a remote hearing when one side wants it and one side doesn't. The other thing I've found interesting to watch is the evolution of procedural instructions that arbitral tribunals have developed to protect the due process in a remote hearing. The lists of questions to the witness: are you alone in the room? Do you have any phones? Do you have any access to the outside world? 365-degree cameras, watching witnesses very carefully, whole lines of instructions and answers that have to go on the record in terms of witness testimony. I think we're going to see more fights over requests for remote hearings to limit long-haul travel or time zone problems or whatever, and tribunals wrestling more with that balance that you've just talked about. Anyway, questions, comments from our erudite audience? Vivek, probably introduce yourself for posterity.
Sure. Good evening, Professor. My name is Vivek. I'm at the SIAC. Firstly, congratulations on completing this massive project, I think which adds tremendously to all of us. My question to you concerns whether the committee has considered or intends to consider in the future the question of the desirability of a physical hearing in arbitration as opposed to the right to a physical hearing. And I ask this because of your comment about how there is this tension between due process concerns and expeditious resolution of disputes that exists today. I think one of the courts pointed that out. And it seems counterintuitive because it appears that the reports suggest that the due process concerns actually are minimal in the case of a remote hearing. And it appears that most jurisdictions bless the possibility of a remote hearing. So Is the tension between due process and expeditious resolution somewhat esoteric, and does that address the question of the desirability of a physical hearing in the larger scheme of things in present circumstances as opposed to COVID? And if the committee is not addressing that, curious to hear your personal views.
So yeah, the first answer is no, we didn't ask that question in terms of desirability of physical hearings over remote hearings. I think that the blessing was also the result of the circumstances that we were living at the time of the reports, where of course the tension between due process on the one hand and, as I said before, the duty to conduct an arbitration proceedings in an expedited manner obviously was leaning toward the second value, but this is now readjusting, in my opinion. It will be harder to justify a remote hearing over a party's objection only because it is more convenient in terms of, flights that you are, time that you are saving, or elements like that. So while before there was a serious justification for remote hearings, now in more ordinary times the landscape is changing again. So I think there will be there is the need to rethink a little bit our questions to the national reporters. So maybe we can. In asking for updates, we may also considering adding a question such as this one. I would like to mention that in the volume there is a survey, another survey that we did with the arbitration institution, where we try to collect data from arbitration institution on what they experienced with the remote hearings, also try to understand whether remote or physical hearing were considered more desirable in a certain industry, or where the value of the arbitration was very high as compared to very low. And maybe because the times were extraordinary, we didn't find any consistent outcome that was justifying the what we were hearing a lot in many conferences, that remote hearings are popular when maybe the value of the arbitration is not as high, or in certain complex arbitration it is preferable or more desirable to have a physical hearing. We tried to unpack all the data we collected, and we couldn't find any coherent answer. But again, maybe because of the extraordinary times, so it's useful to collect the data again in the future.
Thank you.
Loretta Malintoppi, independent arbitrator. I was curious to find out whether you actually have asked arbitral tribunals as well about their practice and procedure concerning virtual or remote hearings. And in particular, if you collected some, for instance, templates for procedural orders, because we all know that there was a point in time that we were preparing in parallel virtual or remote procedural hearing orders and those in persons, and then would choose the last minute, depending on the conditions of the pandemic, which ones we would opt for. Have you thought about doing that sort of thing? Because I think a practical aspect would be very useful for the arbitration community as well. And just another little observation is, of course, the pandemic is over, but reasons for having virtual or remote hearings still exist. And the Russian aggression of Ukraine is one example of situations where parties that come from that region cannot attend hearings in certain countries, cannot have visas, for instance. So they're very much, this form of hearings are very much to stay, I think, in our life as arbitration practitioners.
So, Loretta, thank you for the question. No, we did not consult arbitrators. We did not collect models of procedural orders. What we did was to include one essay on practical matters related to remote hearings, which was written by Hussein Heri and Camilla Gambarini, which includes some of the more practical aspects or new techniques implemented by arbitrators, but we did not survey arbitrators as a community. We did ask to the institutions involved in our survey the data on in how many cases arbitrators order a remote hearing over a party's objection, and in how many cases they refrain to order a remote hearing over a party's objection. And this is an interesting result depending on the regional location of the institution. For example, in Italy, even though, in my opinion, there was no doubt that remote hearings were fine, arbitral tribunals were very cautious to impose a remote hearing. So in most cases, the Milan Chamber of Arbitration told us that arbitral tribunals did not proceed with a remote hearing and preferred to wait. This also applied for the Cairo Center, and in other cases, the answer was different. So we have data that also relate to the practice and the approach taken by arbitrators, but we did not consult them directly.
I would say that the project was a comparative law project, so the focus was on the legal issues, and probably our rapporteurs and editors don't want to do another whole project. But it might help if I just read you the titles of the essays. You might want to download some. Besides the general report on the surveys, part 1 covers international law perspectives on remote hearings, access to justice and the right to a hearing in arbitration. Beyond domestic law, what constitutes a hearing in international arbitration? That's by Chester Brown, among others. Remote hearings and the right to a fair hearing in public international law. Part 2 is entitled Remote Hearings at the Intersection with Data Protection, Psychology, and Diversity. And the chapters are Remote Hearings, Observations on the Problem of Personal Data Protection and Cybersecurity. The Psychology of Remote Hearings. Remote Hearings and Diversity, Some Preliminary Thoughts. That's actually by Yasmin Lalou, one of the editors. Part 3 is Practical and Empirical Considerations on Remote Hearings. Remote hearings, practical considerations, when is it suitable, how to plan for it, etc. It starts into some of the management issues, and then remote hearings, the arbitral institution's perspective. I think a couple, as often happens, almost customary rules, practice rules are emerging. For example, I have been in several cases, and probably others in this room have as well, where the hearing is remote. It's been decided usually long ago it will be remote, but the arbitrators sit together. If all 3 arbitrators cannot sit together, then none sit together. All 3 have to participate from separate locations for obvious reasons. Most of us who are arbitrators who are sitting physically together again, even if it means having the parties and the witnesses on a screen, are very happy with that, because there's very little opportunity to kick each other under the table or take a break or pass notes or have some of those necessary unscripted, uncalendared times to discuss things. I find it very important. And the other thing many of us have observed is when you do a remote hearing of a week or longer, and let's leave aside the time zone issues, which can be a serious practical issue, they're in many ways hardest on the arbitrators, because the arbitrators are on screen all the time. Unlike in here, no yawning, no doing your email, no daydreaming, full attention, which is good for the hearing, but it's very tiring. The parties can be off. If they're not advocates on screen, they can be doing whatever they're doing. The witnesses are on briefly. So it is very tiring for arbitrators, and increasingly tribunals are saying, we really cannot sit more than 6 hours. We know that you're prepared to do 10, whatever, but we really cannot pay attention that long. So that's, I think, an important consideration in a kind of a soft but important due process.
It can be a question of due process, exactly, because of course that hinges on the time that the parties have to present their cases. Because if you only have 6-hour hearings, which I agree is the maximum that one can stand humanly, that means having more compact hearings, shorter hearings, and parties may not like it at all, in fact, or one of the parties may not like it and scream due process violations.
Pem Siring, I'm an associate at Sidley Austin. My question is primarily for Rachel, but then this may be relevant to other jurisdictions now as we see more cases coming up. It was what you'd mentioned about, I think, one of the court cases and the decision to, was it refuse leave to participate remotely, right? Because that strikes me as, I mean, it's interesting because it's about, allowing parties the right to confront, almost as if like that's the if I understood correctly, that's how you'll get the full satisfaction of cross. So, which I'm examining the witness, right? Now that we are in this, era of hybrid hearings where you may have certain witnesses who will participate remotely, do you see a risk, given this decision and maybe some similar, that parties may now try to bring into question the sufficiency of certain testimony that was received remotely by saying, this is what the standard that the court has sort of set out, right? Because I can think of in the past where we didn't have the possibility of doing remote testimony, you had to make this call about, whether you want to bring certain witnesses in front of the tribunal, right? Because the tribunal wants to see some witnesses, but then you make a call, you don't bring them for whatever reason, and then it's at your own risk, right? So in that sense now, whatever the internal strategizing may be, do you see that parties might try to bring that line of sort of argument saying that remote testimony is insufficient because you don't get the satisfaction of doing the full sort of in-person confrontation?
Connected to the fair evidence rule.
So I think my answer I'll take the question in two parts. So the first part is, in that specific case, Singapore High Court case, the decision was issued in November 2022. So I think at that time, the court had given notice that the plaintiff could have flown in. And it's very interesting because the court said that if the plaintiff wants video link evidence, no. But if a third party wants to give, who is not related to the suit, wants to give third party evidence, maybe. But that was not a live issue. And the reason why the plaintiff has to come and give evidence is because you are bringing the claim. How does it appear to the defendants if I allow you to testify via video link? Then the defendants will be very upset, right? So that's why the court said in that situation, I don't allow the application under the Evidence Act. And that was a domestic litigation case, High Court. To the second question of whether, of course, parties can use it as an excuse to extract the general principle that it is still not fair, right, if one person appears via video link. I would say that then we look to the Curio law. And in Curio law, at least for Singapore, which is the only jurisdiction I can comment upon, Curio law is quite clear that the tribunal has substantial deference. That's what it says in China Energy Core. But fact-specific. So I can think of certain situations where having a witness testify via video link will breach the fair hearing rule. And one of the situations which I was thinking about last night was, I have been in certain hearings where the internet connection is so bad just because it is in a particular jurisdiction where a storm wipes out the entire country's internet connection that I can barely hear what the other party is saying. This is in my position as counsel. Much less the tribunal who is 12 hours behind. It cuts in and out. I hear a sentence, half a sentence, and then the rest, half a sentence. I really do not know how the transcription is being written. So in that situation, if the tribunal does not say, stop, let's fix the internet connection, I could see a real possibility that a party may argue, this is not a fair hearing. I have not had the opportunity to present my case. And in that hearing, the written submissions were excellent. The written record was full written record. It was the oral hearing that was a little bit difficult to conduct. So in certain situations, I would say that the Court of Appeal would look at the facts of the case and perhaps would consider it and then determine the scope of the fair hearing rule in this situation. Thank you.
Other questions, comments? Yes. Please.
Hello, I think I will stand because I'm rather short so that you can see me. My name is Yue. I'm a deputy counsel at SIAC. Thank you for this great presentation and congratulations on this giant project, which is timely and meaningful in my opinion. I am not posing a question, but I'm trying to make a comment. I happen to be reading a case from the Swiss court in 2020, and it says that COVID-19 is not a sufficient justification for virtual hearing in litigation. But in stark contrast to this decision from the court, the Swiss court has a long line of cases supporting virtual hearings in arbitration. So I am thinking, why, like the Swiss court, have quite different opinions in terms of the right to a physical hearing. And I try to observe this topic from a broader perspective, because yes, we're talking about the right to a physical hearing, which is a legal issue, but maybe the answer can be found in a broader perspective, such as like cultural elements and like policy considerations. For example, Switzerland, Geneva, and it's a very popular seat of arbitration. And maybe the court think, okay, if I say, well, no right to virtual hearing, then that may cause damages to the industrial development in terms of arbitration. Another example is from the country where I am from, it's China, is that we know that there is no legislative support in terms of virtual hearing, but in terms of practice, it's really popular. And in the draft amendment put forward by the Ministry of Law for the arbitration law, which hasn't been approved by the legislature, there is a new provision expressly supporting virtual hearing. And I'm thinking why China is so like proactive in terms of virtual hearing. It is likely that like China is trying to advertising its advantages in terms of everything online. So it cannot say no to virtual hearing. So that is kind of my comment, is that not only a right to physical hearing, maybe like a broader perspective to this topic.
If I can comment on your first point about Switzerland, I think it's another angle to try to understand why in many rules of civil procedure we find the right to a physical hearing, and in the arbitration acts, arbitration laws. No, of course, it's also a matter of the timing of when the laws were written. So many rules of civil procedure, at least in Europe, were written in the 40s, in the 50s, so in a time where, of course, this technological development was not conceived. So the many national reporting were stressing the fact that this right is more a relic of the past, but physicality against does not translate into a fundamental procedural principle. Arbitration acts are normally more recent, so they were written with a different set of mind. Well, Switzerland is even a more peculiar case because it's the only jurisdiction where actually, even if the parties agreed on holding a hearing, even if they agreed on arbitration rules that provide for a right to a hearing, the arbitral tribunal can deny a hearing altogether and the award will be valid. So not only a remote hearing is obviously okay, but the arbitral tribunal can go even farther and deny a hearing altogether. So that is an exception of Switzerland that emerges from our survey. In Italy, for example, the Code of Civil Procedure provides that you are not allowed to bring sticks and weapons during a hearing. So, of course, it is a physical one because, I mean, remotely, it's holding a stick doesn't help. But again, I think it's more a relic of the past than a meaningful legal, provision.
And Lawrence.
I just add to the comment of the right to a physical hearing. season, parties cannot attend the hearing, or tribunal members cannot gather together or congregate. So there is an agreement that we have remote hearings. I have a situation in which that was agreed, but one party says we can come and we would like to come. The other party then says, no, you can't attend because we cannot be there and therefore you cannot be there. So are we depriving one party of the right to be heard and the right to be heard physically just because the other party cannot attend? So that is a different question. That do we need to balance the right to be heard in the sense that both parties must be heard physically, or can we hear one party physically and the other party remotely? So the party who wants to come says, I can attend, and you can attend too if you are able to. I'm not saying you don't have the right to come. So this is a different permutation. So is that being considered in your report? Was there scenarios of this sort?
It is not, because I think in that moment we were considering fully remote hearings only, and hybrid hearings was a later development with different and new challenges as the one you described. So it is not covered by our project.
I think several of us are encountering this situation, sometimes suspecting that the party who says they cannot come are doing it strategically. Sometimes it's genuine because of their vaccination status, travel, whatever. Then the tribunal is in the difficult spot of making a decision. We go forward remotely for efficiency, expediency, and to get going, or we'll wait until both sides can attend. And that's where the results of the surveys are helpful, because tribunals want to know, if I do order a remote hearing over the objection of one side not being convinced of the legitimacy of the reasons for not appearing, then my award most likely will not be vulnerable. I shouldn't make predictions, I'm usually wrong, but I can see going forward a positive development in our profession, which is that core hearings are back to being in person with the arbitrators, the lead advocates, main witnesses, everything being streamed live where technology allows it, depending on venues, so that witnesses who are only going to be questioned for a half an hour or an hour don't have to travel, so that many of the juniors can actually watch the hearing, which they wouldn't have been able to do if they had to travel. And we'll be making videos of the hearings, which will be useful for the tribunal. But we'll stay away from sides where one party's in person and one party is not, or one arbitrator is there, one party is not. And the institutions and the hearing centers and the hearing concierges, or whatever you call, OPIS and the like, will have to be adjusting to this. Any more questions? We've hit 5:15. Thank you all. I'll invite I want to thank you both for being here. And we have our formal closing. Thank you, Nusri.
Thank you, all of you. On behalf of SIAC, I express our sincere gratitude to our speakers tonight. Thank you so much for being here from your busy schedules and taking this moment to share it with us. And for our guests, thank you so much. We appreciate you all joining us, and I hope this discussion here has been fruitful and thought-provoking. And special thank you to Lucy Reed for driving this with Shirley and Andres. Thank you so much. And a special thank you to Gloria, Kevin, Minji, the business development team, and IT for helping us get through this. Thank you all. Have a pleasant day.